All right. So now, because of Griswold versus Connecticut, we have this court-created right, judicial activism, court-created right of the right to privacy. And so, how far does that right to privacy go? We have no idea because there were no committee hearings to ferret that out. That's how laws are passed, in committee, then by the whole House and the whole Senate. Without that examination, you don't know what the laws mean. So when the court's creating a right, you're opening up Pandora's box, and you never know what's inside that box. So here we go. So in 1973, there was a case. A pregnant single woman by the name of Roe brought a class action lawsuit challenging the constitutionality of the Texas criminal abortion law. So it used to be a crime to abort babies, fetuses, whatever you want to call them, which prescribe curing or attempting abortion except on the medical advice for the purpose of saving the mother's life. She, meaning Roe, claimed that the Texas statutes were unconstitutionally vague and they abridged the right of personal privacy protected by the 1st, 4th, 5th, 9th, and 14th Amendments. By an amendment to her complaint, Roe purported to sue on behalf of herself and all other women similarly situated. So she's taking the right created in Griswold versus Connecticut that was just made up out of whole cloth from these amendments, and she's saying she has a right to an abortion. Now, it really all depends on where the court wants to go, and the court at the time was dominated by liberals. And so if you look at this, this is the part of the court's opinion. Now I want you to look at this thing. This is what I'm going to ask you on the test. Look at that. What does it look like to you? Well, if you've looked at any laws before, that's what it looks like. It looks like a law. It's got a number here, subsections, another number. This is what laws look like, not court decisions. In other words, the court is writing a law. And so this is what they're saying in the law that they're writing. And it's all based on the woman's right to privacy. A state criminal abortion statute of the current Texas type that accepts from criminality only a life-saving procedure on behalf of the mother without regard to the pregnancy stage and without recognition of the interest involved is violative of the Due Process Clause of the 14th Amendment. And so then they start to say when and when can't the state prescribe it. So A, for the stage prior to approximately the end of the first trimester, the abortion decision and its effectuation must be left to the medical judgment of the pregnant woman's attending physician. B, for the stage subsequent to approximately the end of the first trimester, state in promoting its interest in the health of the mother may, if it chooses, regulate the abortion procedure in ways that are reasonably related to maternal health. So in other words, if the woman's health is in danger, she can still have an abortion. If it's not in danger during this approximately in the first well, let's get to C. For the stage subsequent to viability, so viability is when the fetus, the baby, can live outside the womb on its own. The state, in promoting its interest in the potential for human life, may, if it chooses, regulate and even prescribe abortion except where it is necessary and appropriate medical judgment for the preservation of the life and health of the mother. So this is where the law went. So you can see here, this is a law. This is a law that they wrote in their judicial opinion. This is judicial activism at its worst, at its absolute worst. Now, you may agree that a woman should have the right to an abortion. The problem is, this is not the way to do it. This is not the way to do it by judicial decree. This is something that should have gone through the legislature. The fact that it was only capable because of another Supreme Court justice case, which was decided on a judicial activist philosophy, which led to this case. So what I want you to understand for the test is I want you to understand that Roe v. Wade looked more like a legislative law than your judicial opinion. And again, just so no one misunderstands where I'm at, I don't care which way you view abortion. But for the purposes of this lecture, you can see here how with judicial activism, you never know where a law is going to go. Furthermore, it's also telling that, as we read in one of the As we read in West Coast Hotel versus Parrish, they admitted that Lochner Rising was long. The majority admitted that. And then what did they do in Griswold versus Connecticut? They Lochnerized. What did they do in Roe versus Wade? They Lochnerized. In this instance, we are living under a catocracy, ruled by judges, non-elected, non-removable judges. So what did it all lead to? So in 1950, what percent of births were out of wedlock? What percent of births were out of wedlock? Just take a guess. What do you think? Okay, we're going to tell you now. 4% of births were out of wedlock. Wow, that's pretty low. That's good. That's good. 2010, what percent of births were out of wedlock? Where are we at? 41%. What happened? What happened? What happened was Griswold versus Connecticut, Neinstedt versus Bear, and Roe versus Wade. This is one of those things where the judicial branch used, quote, their wisdom, said, we think this is a good idea. We think this is a good idea. The woman should have this right. Look what happened. What is happening to the foundation of our society? What is happening to families based on that? Now, we can look at it in an even different way. What about unwed births by race? And again, you look at these races, and nobody is more concerned about this than certain races, because it is hurting them as a race. So let's just look at that. So here we are. Asian, what percent of Asians are out of wedlock births? 17. Whites, 29. Hispanic, 53. Native American, 66, and black, 72%. So when you have these kind of figures out of wedlock births, it is really hurting the race. It is hurting the culture. It is hurting the country. And all this because some judges decided to use their own wisdom, what they thought was wise and just, what was necessary versus unnecessary. And you can even take a look at this from another perspective. What about minor abortions and parental involvement or notification? You can see from this chart that in many states you don't even have to have parent consent for a minor to get an abortion. A minor can't buy their own car insurance. They can't buy their own car, but they can abort their fetus without their parents' consent. There you have it. I hope you enjoyed this. Hope you understand constitutional interpretation a little bit more, and this all made sense. If it didn't, email me some questions.